Ron Callahan leaned back at the head of the conference table. "We have recorded documents showing the boundary adjustment and easement agreement. The county approved our building permit. Everything we've done has been legal and above board." The meeting was a formality. Like the house on my family's land was theirs because paperwork had been filed. What he didn't know was that the entity listed as grantor on his easement had never been registered with the Secretary of State. This wasn't a boundary dispute or permit approval. 87 acres, 72 years of continuous family ownership. A 2-story structure 22 to 38 feet inside my property line. An HOA betting documentation beats deed. Ron made the mistake bureaucrats always make, assuming that because something had been recorded and approved, it must be legitimate. It wasn't. Over 3 months, I watched the Lakeview Ridge Homeowners Association discover what happens when you build on someone else's land, using fabricated paperwork, and the real owner shows up with a surveyor. 70 years of clear title. This is the story of how an HOA that built an amenity house without permission learned that recording fraud doesn't create rights. It's not because I sued first. It's because I removed the trespass myself and let them explain to a judge why they thought that was illegal. But let me start from the beginning. Before we dive into, I'd love to know where you're listening from today. And don't forget to hit the like and subscribe buttons for more interesting stories just like this. The property has been in my family since 1952. 87 acres of rolling hills and timber, bordering a creek on the north side and a gravel access road on the south. My grandfather bought it with money he saved working construction, built a small house near the center of the parcel, and raised cattle on the cleared sections while leaving the rest wild. My father inherited it in the 80s, paid off the remaining mortgage, and kept it exactly as it was: quiet, undeveloped, and wholly ours. When he passed 3 years ago, he left it to me with a single note tucked into the deed folder. "Don't let anyone take this from you." It didn't plan to. The land was paid off, clearly platted, and recorded with the county since before most of the surrounding area was even developed. I used it on weekends, kept the trails clear, and occasionally let neighbors with permission use the access road to reach the creek for fishing. About 6 years ago, a development company bought the land to the south, 200-acre parcel that had been farmland, and started building Lakeview Ridge, a gated community with luxury homes, a clubhouse, and all the usual HOA amenities. The development bordered my southern property line, separated by the gravel access road I'd been using for decades. There was some initial tension when they tried to pave the road and claim it as part of their community infrastructure, but a quick survey and a letter from my attorney settled that the road was on my side of the line. It was mine. They backed off, built their own entrance a quarter-mile east, and that was the end of it. Or so I thought. I'd been away for 5 weeks, traveling for work and then staying with my sister in Oregon while she recovered from surgery.
Of the property
Sat empty during that time, locked up, no activity, just land doing what land does when nobody's disturbing it. I got back on a Thursday afternoon in late September, driving up the gravel road with the windows down, breathing in the smell of pine and damp earth. The leaves were starting to turn, and the air had that cool, clean edge that comes with fall in the high country. But as I rounded the bend near the southern boundary, something looked wrong. There was a structure where there shouldn't have been. One. I stopped the truck and got out, staring across the fence line at a partially framed house sitting in the clearing about 30 feet from the road. 2 stories, wood framing, Tyvek wrap on the exterior walls, windows already installed on the first floor. Construction equipment parked nearby, a small excavator, a trailer full of lumber, a porta-dash potty, and a banner stretched across the front of the structure. Future Lakeview Ridge HOA amenity home, short-term guest stays. I walked closer, my boots crunching on gravel, and stopped at the fence. Fresh survey stakes dotted the ground, bright orange ribbons tied to the tops, running in a line that put the new structure squarely on what I'd always known was my land. I pulled out my phone and opened the county GIS app. It's the one that shows property boundaries based on recorded plats. I zoomed in on my location, waiting for the parcel lines to load. When they appeared, my stomach dropped. The new house sat at least 20 feet inside my property line. Maybe more. I zoomed in further, cross-referencing the boundary with the physical. Landmarks: the road, the tree line, the old fence posts my grandfather had set in concrete back in the 60s. Every reference point confirmed the same thing. That house was on my land. A man in a hard hat and high-waist vest walked out of the structure carrying a clipboard. He saw me standing at the fence and waved, then walked over with the easy confidence of someone who thought everything was in order. "Can I help you?" he asked, stopping a few feet away. "I own this land," I said, keeping my voice calm. "Everything on this side of the road and that house you're building is on my property." He frowned, glancing back at the structure, then at his clipboard. "No, this is Lakeview Ridge, HOA property. We've got permits, surveys, the whole thing. This is the new amenity house." "It's not HOA property," I said. "It's mine. I've owned this parcel since 2021. My family's owned it since 1952. That house is at least 20 feet over my boundary line." The foreman shook his head, not hostile, but dismissive, like I was confused. "Look, I don't know what to tell you. The HOA gave us the go-ahead. They said they fixed the plat a few months back, adjusted the boundary to include this section. It's all recorded with the county." I stared at him. "Fixed the plat? Some kind of correction or amendment? I don't deal with that stuff. I just build where they tell me to build. But if you've got an issue, you need to take it up with the HOA, not me." "Who's your contact at the HOA?" I asked. He flipped through his clipboard and pulled out a business card. "Guy named Ron Callahan. He's the president. Here's his number." I took the card, thanked him, and walked back to my truck, my pulse ticking up with every step. They'd fixed the plat, adjusted the boundary, without telling me, without asking permission, without a signature or a sale or any kind of legal transfer. And now there was a house, a nearly finished house sitting on land that had been in my family for 70 years. I sat in the truck and pulled up the county recorder's website on my phone, searching for recent filings related to my parcel. It took a few minutes of scrolling, but I found it. Corrected plat, Lakeview Ridge, HOA filed. April 12th, 2024 description. Boundary adjustment, correcting surveyor error from original 2018. Plotty clicked through to the attached documents. The corrected plat showed a new boundary line, shifted west by about 30 feet. Carving a 0.4-acre strip off my property and labeling it Lakeview Ridge HOA Common Area, Amenity Parcel. There was also an easement and access agreement recorded, the same day purporting to grant the HOA's permanent rights to use, improve, and build on the newly claimed parcel, the grantor listed on the easement. Mitchell Ridge Holdings, LLC. I didn't have an LLC. I'd never created one. My property was held in my name personally, fee simple, exactly as it had been since my father's estate transferred it. To me, Mitchell Ridge Holdings didn't exist. Someone had fabricated an entity, forged documents in its name, and recorded a fake plat amendment to steal a piece of my land, and then they'd started building on it. I called my attorney, David Nguyen, a property lawyer I'd worked with during the estate transfer. He answered. On the second ring. "David," I said, my voice tight. "Someone just built a house on my land without my permission, and they recorded fake documents with the county to make it look legal." There was a pause. "Say that again?" I explained everything: the house, the corrected plat, the fake LLC, the easement agreement. David listened without interrupting, and when I finished, he exhaled slowly. "Do not touch that structure. Do not. Talk to the HOA or the foreman again. Send me everything you just found, screenshots, links, photos. I'll pull the full file from the county tomorrow and see what we're dealing with." "What do I do in the meantime?" I asked. "Document everything. Photos, measurements, GPS coordinates, and if they're still working on the house, record them doing it. Because if this is what it sounds like, we're not just dealing with trespass, we're dealing with fraud." I hung up and spent the next hour walking the fence line, taking photos of the house, the survey stakes, the construction equipment, and the banner. I used my phone's GPS to mark the coordinates of the structure and cross-reference them with the county. GIS map, every angle confirmed the same thing. The house sat on my land, clear as day, with no legal right to be there, and someone at the Lakeview Ridge HOA had gone to significant effort filing documents, hiring contractors, getting permits to make it look like it belonged to them. Stood at the fence as the sun started to set, staring at the framed structure with its Tyvek walls and fresh-cut lumber, and felt something cold and sharp settle in my chest. They hadn't just made a mistake. They'd committed fraud. Filed false documents, built on land they'd stolen, and now I had to decide how far I was willing to go to take it back. I pulled out the business card the foreman had given me and looked at Ron Callahan's name and number. Tomorrow, I'd call him. I'd give him a chance to explain, to fix this, to tear down what they'd built and admit they'd crossed a line. But if he didn't, then I'd show him exactly what happens when you build a house on land you don't own and hope the real owner doesn't. Notice I was at the county offices when they opened Friday morning. The building was one of those low brick structures from the 70s, with fluorescent lights that hummed and hallways that smelled like old carpet and copy toner. I went straight to the recorder's office on the second floor, carrying a folder with my deed, my father's estate documents, and printouts of everything I'd found online. The clerk at the counter was a woman in her 60s named Linda, who'd worked there long enough that her desk had family photos going back to when the building was new. She greeted me with the practiced politeness of someone who'd helped thousands of people navigate property records. "I need to pull everything recorded against my parcel in the last year," I said, sliding her a slip of paper with the legal description and parcel number. Linda typed it into her system and waited for the results to load. Looks like 3 documents: corrected plat, an easement agreement, and a building permit cross-reference. "Want me to print them all, please?" She printed the documents and handed them across the counter. I spread them out on the public research table near the window and started reading. The first was the corrected plat of Lakeview Ridge. Phase 2, filed April 12, 2024. It showed the original boundary line between my property and the HOA development. Then a revised line labeled corrected boundary per survey amendment that shifted the line 30 feet west directly onto my land. A small note at the bottom read, "This correction addresses a surveying error identified during Phase 2 development and adjusts the common area boundary to reflect actual use and maintenance patterns." Established since 2018, it was bureaucratic language designed to sound official and boring, the kind of thing most people would skim past without questioning, except it was a lie. There had been no surveying error. The original plat was accurate. This correction was just a land grab dressed up as administrative housekeeping. The second document was the easement and access agreement, also dated April 12, 2024. It granted Lakeview Ridge HOA permanent and irrevocable rights to access, improve, construct upon, and maintain the 0.4-acre parcel described herein, for purposes including but not limited to community amenities, guest accommodations, and recreational facilities. The grantor, the party supposedly giving away these rights, was listed as Mitchell Ridge Holdings, LLC. I stared at that name, feeling my jaw tighten. I'd never formed an LLC. My property was titled in my personal name, exactly as it had been since my father's death. Mitchell Ridge Holdings didn't exist. The signature line at the bottom showed a scrawled name I didn't recognize. It's notarized by someone I'd never heard of, with a notary stamp from a county 2 hours away. It was fake, all of it. The third document was a building permit application approved May 3, 2024, for single-family amenity structure. 2,400 square feet, Lakeview Ridge, HOA common area. The permit had been issued on the strength of the corrected plat and easement agreement, which the county had accepted as proof that the HOA had the right to build there. I walked back to Linda's desk, holding the easement agreement. This document lists the grantor as Mitchell Ridge Holdings, LLC. Can you search your system and tell me if that entity has ever been recorded as owning my parcel? Linda typed for a moment, then shook her head. No record of that name in the ownership chain. Your parcel shows continuous ownership. Your great-grandfather in 1952. Transferred to your grandfather in 1979, to your father in 1986, and to you in 2021. No LLCs, no corporate entities, just individuals. So this LLC doesn't exist, I said. Linda hesitated, choosing her words carefully. I can't say it doesn't exist. It might be registered with the Secretary of State as a business entity, but it's never held title to this property, and it has no legal standing to convey easements or rights related to land it doesn't own. Then how did this get recorded? I asked, tapping the easement agreement. She lowered her voice slightly, glancing toward the back offices. We're not investigators. When someone submits a document with a notary stamp and proper formatting, we record it. We don't verify every signature or check if the grantor actually owns the property. That's supposed to happen during the title search and permitting process. She paused. But sometimes, documents get filed, and people hope nobody checks, especially if the property owner isn't paying attention. I was paying attention, I said quietly. I just wasn't here. Linda nodded sympathetically. You should talk to someone at the assessor's office and the permitting desk. They approve the building permit based on these documents. They need to know there's a problem. The assessor's office was down the hall. I met with a clerk named Jason, mid-30s, who pulled up my parcel on his screen and frowned when I explained the situation. So you're saying this easement is fraudulent? He asked. Yes, the grantor listed doesn't exist, and I never signed anything transferring rights to the HOA. Jason clicked through several screens, comparing the recorded documents to the tax records. The parcel is still assessed to you. The tax bills still go to your address. There's no split or subdivision reflected in our system, 'cause there shouldn't be, I said. The corrected plat is fake. It was filed to make it look like the HOA has rights to a piece of my land, but they don't. Then you need to file a formal objection with the recorder and probably get a court order to void the plat and easement, Jason said. Until that happens, these documents are on the books, and they're being treated as valid. I thanked him and went to the permitting desk on the first floor, the permitting clerk. A woman named Sandra pulled up the building permit for the amenity. House permit was issued in May. Inspections have been passing. Framing, electrical, plumbing all signed off. The permit was issued based on fraudulent documents, I said. The easement that supposedly gave the HOA the right to build was filed by a fake entity that doesn't own my land. Sandra's expression shifted from professional to concerned. If that's true, the permit shouldn't have been issued. But we rely on the plat and easement being valid. If they're not, the HOA is building without legal authority. She made a note on her screen. I'm flagging this permit for legal review. Construction should stop until this is sorted out. Will it stop? I asked. I can't force them to stop without a stop work order from a supervisor or a court. But I'm documenting your objection. If they keep building and this turns out to be fraudulent, they're doing so at their own risk. I called David Nguyen from the parking lot and told him everything I'd found. I'm coming to your office, he said. I want to see these documents in person. We met that afternoon at his office, a small suite in a converted house near downtown. David was in his early 50s, methodical and patient, with the kind of calm demeanor that made you feel like problems could be solved if you just worked through them step by step. He read the corrected plat and easement agreement slowly, making notes, then looked up at me. This is textbook fraud. Fake entity, forged conveyance, recorded to create a false claim of right. The question is whether the HOA knew it was fake or relied on someone else's bad paperwork. Does it matter? I asked. Legally, yes. If they knowingly filed false documents, that's criminal. If they were duped by a developer or title company, it's still trespass, but the intent is different. He set the documents down. Either way, you have clear rights here. That house is on your land. You didn't consent to it. You have the legal authority to remove it. I blinked. Remove it? David nodded. Anything built on your land without your permission is considered a trespassing structure. You can demand they remove it, or you can remove it yourself and bill them for the cost. It's your property. You're not required to let someone else's mistake or fraud sit there. Can I really just tear it down? I asked. You'd want to do it carefully, document everything, use a licensed contractor. Give them notice first so you're not accused of acting in bad faith. But yes, legally, you can remove a trespassing structure from your own land. He leaned back in his chair. That said, I'd recommend we try to resolve this without a bulldozer first. We file a quiet title action, get a court order declaring the plat and easement void, and demand they remove the structure. If they refuse, then we escalate. How long does that take? I asked. Months. Maybe a year. And in the meantime, they'll keep building unless we get an injunction. What if they finish it before the court rules? I asked. David smiled grimly. Then they've invested a lot of money into a structure sitting on land they don't own, which gives you even more leverage. I hired a surveyor that afternoon, a firm David recommended, run by a woman named Karen Delacroix, who specialized in boundary disputes. She met me at the property on Saturday morning with a crew and enough equipment to map the entire parcel down to the inch. Karen worked methodically, checking old survey markers my grandfather had placed in the 60s, comparing them to the county's recorded plat, and using GPS to establish the exact boundary line. When she finished, she walked me to the fence and pointed at the house. That structure, she said, is entirely on your property. The nearest corner is 22 feet inside your boundary line. The farthest corner is 38 feet in. There's no ambiguity. It's not straddling the line. It's completely on your side. The corrected plat they filed. I asked. Karen pulled it up on her tablet and compared it to the actual survey. The corrected plat is fiction. The original boundary was accurate. Someone shifted the line on paper to make it look like they had the right to build here. But the physical reality hasn't changed. This is your land, and that's their house sitting on it. She handed me a USB drive. Full survey report, GPS coordinates, photos, and a legal description you can use in court. If you need me to testify, I will. I met with David again on Monday. He'd reviewed Karen's survey and was drafting a formal demand letter to the HOA. Is as clear-cut as it gets, he said. They built an entire house on your property based on fraudulent documents. You have every right to demand removal. What if they refuse? I asked. David looked at me seriously. Then you make a choice. Yet, you can wait for the courts to order them to remove it, which takes time and money. Or you can exercise your rights as the property owner and remove the trespassing. Structure yourself. You mean tear it down? I mean remove the trespass from your land. Yes, he paused. It's aggressive. It'll make enemies. But it's legal. And sometimes, when someone builds on your land and refuses to leave, the only way to make them understand is to show them you're serious. I stared at the survey report, at the photos of the house sitting on land my great-grandfather had cleared 70 years ago, and felt something harden in my chest. They hadn't asked permission, hadn't negotiated, hadn't even told me. They'd just filed fake paperwork, built a house, and assumed I'd never notice or never fight back. They were wrong. Send the demand letter, I said. Give them 2 weeks to remove it. And if they don't, I'll handle it myself. David nodded. I'll draft it today. The demand letter went out by certified mail on Tuesday, addressed to Ron Callahan, HOA president. And the Lakeview Ridge Board of Directors. It was 3 pages long, professional, but unambiguous. Laying out the facts with surgical precision, the corrected plat filed in April was invalid. No legal conveyance had occurred. Mitchell Ridge Holdings, LLC, did not exist and had never owned the property. The easement agreement was void. It's executed by a fabricated entity. The amenity house sat entirely on my property, 22 to 38 feet inside. My boundary line. The HOA had 14 days to halt construction and remove the structure at their expense. Or I would pursue all available legal remedies. David attached the survey report. Photos, the chain of title going back to 1952, and a corporate search showing no record of Mitchell Ridge Holdings in the state registry. Ron Callahan called me 2 days later. We need to meet, he said, his tone clipped. This has gotten out of hand and I think there's been a misunderstanding. There's no misunderstanding, I said. You built a house on my land without permission? Let's talk in person. Tomorrow. Night, 7 MHOA, Clubhouse. Bring your attorney if you want. We'll get this sorted. I agreed. Though I had no illusions about what sorted meant to him, the Lakeview Ridge Clubhouse was the kind of building that screamed luxury community stone facade. Vaulted ceilings, leather furniture in the lobby, and a conference room. With a table, that could seat 20. David and I arrived a few minutes early, carrying a banker's box with copies of every document we'd need. Ron Callahan was already there, seated at the head of the table with 4 other board members flanking him. Ron was in his late 40s, tan and fit, with the kind of easy confidence that came from years in real estate development. He wore a blazer with no tie, and his handshake was firm and practiced when he greeted us. "Thanks for coming," he said, gesturing to seats at the opposite end of the table. The power dynamic was obvious as versus them, outnumbered, with Ron controlling the room. David and I sat down. I set the banker's box on the table but didn't open it yet. Ron folded his hands and leaned forward slightly. "Look, I understand you're upset, but I think we can resolve this quickly if we just look at the facts." "I agree," I said. "Let's look at the facts." Ron slid a folder across the table. "We have recorded documents showing the boundary adjustment and easement agreement. The county approved our building permit. Everything we've done has been legal and above board. Except it hasn't," David said calmly. He pulled out the survey report and set it in front of Ron. "This is a professional survey conducted last week. It shows the actual boundary line between my client's property and your development. The structure you're building is entirely on his land, 122,238 feet inside the line." Glanced at the survey but didn't pick it up. "We have our own survey. It shows the corrected boundary." "Your survey is based on a fraudulent plat," David replied. "The corrected plat you filed in April claims to adjust the boundary, but it was executed by an entity, Mitchell Ridge Holdings, LLC, that doesn't exist and has never owned this property." He slid another document across. "This is a corporate search from the Secretary of State. No such LLC is registered. No such entity has ever held title to my client's land." One of the board members, a woman in her 50s, leaned forward. "You saying someone forged the easement?" "That's exactly what I'm saying," David confirmed. "The grantor listed on the easement is a fabrication. The signature is not my client's. The notary stamp is from a county 2 hours away, and we have no record of my client ever being present for such a signing. The entire document is void." Ron's expression didn't change, but I saw his jaw tighten slightly. "The county accepted it. They recorded it. It's valid unless a court says otherwise." "It's void ab initio," David said. "From the beginning. A conveyance executed by someone who doesn't own the property has no legal effect, regardless of whether it's recorded. Can't transfer what you don't own." "With color of title," Ron said, the phrase rolling off his tongue like he'd rehearsed it. "We've been using this buffer land for years, maintaining it, improving it. Even if there's a technical issue with the paperwork, we've established rights through continuous use." David almost smiled. "You've been using land that isn't yours for 6 years. That's not color of title. That's trespass. And trespass doesn't ripen into ownership when the true owner objects. My client is objecting right now." Ron leaned back, his confidence slipping just slightly. "This is ridiculous. We're building a community amenity. Something that benefits everyone in the area, including you." He looked at me. "You're standing in the way of progress over a technicality." "It's not a technicality," I said, keeping my voice level. "It's my land. My family's owned it for 70 years. I never sold it. I never leased it. Never gave you permission to build on it. Now there's a house sitting on property that belongs to me." "Show me your signature," David added, sliding a copy of the easement agreement across the table. "Point to where my client signed anything transferring rights to your HOA." Ron stared at the document but didn't touch it. "You can't," David continued, "because he didn't sign it. Because Mitchell Ridge Holdings doesn't exist. Because this entire filing is fraudulent, and you built a house based on paperwork that has no legal standing." Another board member, a younger man in a polo shirt, spoke up. "We didn't know. The developer gave us the documents. We trusted them." "That's a problem you'll need to sort out with your developer," David said. "The fact that you're building on someone else's land without permission." Ron's expression hardened. "If we made a mistake, we'll fix it. But tearing down a nearly finished house isn't the answer. We can negotiate an easement. We can pay you for the land. There are solutions here that don't involve destroying property. You should have negotiated before you built," I said. "After. We're trying to be reasonable, Ron said, his voice rising slightly. But if you push this, you're going to tank property values for the entire community. People bought homes here expecting certain amenities. If you kill this project, you're hurting innocent families. I'm not killing anything, I said. You built on land you don't own. That's on you. Ron stood abruptly. Fine. If you want to play hardball, we'll see you in court. We have deep pockets and a legal team that specializes in property disputes. You're one guy with a grudge. Good luck. David stood as well, calmly collecting our documents. You're welcome to file suit. But I'll tell you right now, you're going to lose. And every day you continue construction, you're deepening your liability. My client has the right to remove trespassing structures from his land. If you'd like to avoid that, I suggest you stop building and start negotiating in good faith. Ron's face flushed. If you touch that house, we'll sue you for everything you've got. For removing a trespassing structure from my own property, I asked. Good luck with that. We walked out of the clubhouse, leaving Ron and his board sitting in tense silence. David and I sat in his truck in the parking lot. Windows down, the cool night air cutting through the tension. That went about as well as I expected, David said. Not backing down, I said. No, he's dug in. It's probably because he's realizing how exposed he is. If he admits the plat is fake, the whole project collapses, and he looks incompetent or complicit. So he's going to bluff and hope you blink. I'm not blinking, I said. David nodded. Then we have two options. 1. We file for a temporary restraining order, an injunction to stop construction, while we litigate the title issue. That takes time, and there's no guarantee a judge grants it quickly. And option 2? David looked at me seriously. You exercise your rights as a property owner? Ain't you? Remove the trespassing structure yourself. You document everything, hire a licensed contractor. Video the whole process. Give them final written notice first, so you're not accused of acting in bad faith. And you do it before they finish the house and make this even messier. That's aggressive, I said. It is, but it's legal. You don't need a court's permission to remove a trespass from your own land. And sometimes, when someone refuses to listen to reason, the only way to make them understand is to show them you're serious. I stared through the windshield at the clubhouse, thinking about Ron's smug confidence, his threats, his assumption that I'd back down because he had a legal team and deep pockets. How long would it take to get an injunction? I asked. 2 weeks minimum? Maybe a month? And in the meantime, they'll keep building. They'll rush to finish, thinking that once the house is done, you'll be less likely to tear it down. And if I remove it myself, then it's gone. They can sue you, but they won't win. You'll have documentation showing it was on your land, that you gave them notice, and that they refused to remove it. A judge isn't going to punish you for protecting your property rights. I sat with that for a long moment, weighing the options. Thinking about my father's note, don't let anyone take this from you. Set it up, I said. Final written notice. 2-week deadline, and if they don't remove it, I will. David nodded. I'll draft the notice tonight, and I'll start looking for a demo contractor who can move fast and document everything. One more thing, I said. I want cameras. On the property line, recording 24/7. If they try anything vandalism, intimidation, whatever, I want it on video. Smart, David said. I'll help you set that up. We shook hands, and I drove home. Feeling the weight of what was coming settle over me, Ron Callahan thought he could outlast me. Thought his legal team and his HOA's money would make me fold. He had no idea what happens when you push someone who's got nothing to lose and everything to protect. The house was on my land, built without permission, based on lies. And in 2 weeks, if it was still standing, I was going to make sure it wasn't. The motion for a temporary restraining order was David's idea. It was the polite version of what I wanted to do. Paper. It was simple. I was asking the court to temporarily halt all construction on the amenity house until the title dispute could be resolved. We attached every thinker and survey, the chain of title, the fraudulent plat, the fake easement, and photos showing the structure clearly inside my boundary. 2 weeks later, we were standing in front of Judge Harlan in a cramped courtroom with bad acoustics and an overworked clerk. The HOA's attorney was there too, a litigator named Benson with perfect hair and a talent for sounding offended on command. David laid it out clearly. My client is the record owner. The house is on his fee simple parcel. The boundary correction was executed by an entity that never held title. If construction continues, the harm is irreparable. Once they finish, the pressure to let it stand only increases. We're asking for a temporary stop so the court can sort out title first, Benson countered with practiced indignation. The HOA relied on recorded documents and a county-approved permit. Stopping construction now would cause enormous financial harm and disrupt an entire community. If the neighbor wants to claim trespass, he has other remedies. This is not what emergency relief is for. The judge flipped through the filings, skimming more than reading. When he finally spoke, he sounded tired more than anything else. I'm not deciding title today, he said. You want a quiet title? File the proper action. As for a temporary restraining order, I don't see the kind of imminent, irreparable harm that justifies emergency relief. If they're trespassing, you have other remedies under property law. Motion denied. David started to speak, Your Honor. Once this is finished, the judge held up a hand. Counsel, I said I'm not stopping construction. File your title. Case and let it move in the normal course. This court is not going to micromanage an HOA's building project on an emergency docket. He signed the order and moved on to the next case. Outside in the hallway, David folded the denial and slipped it into his briefcase. Well, he said, the judge just confirmed what I already told you, that they're trespassing and... I still have remedies, I said. Exactly. He refused to protect them. He also refused to protect you. Which means the law is back where it always was. It's your land, and you decide what happens on it. The HOA took the denial as a victory lap. Within days, construction went into overdrive. Extra trucks, longer hours, lights on after dark. They pushed to get the roof on and the exterior wrapped, like finishing the shell would magically transform a trespassing house into legitimate community infrastructure. Screenshots of board emails made their way to me forwarded by a couple of residents, who were less impressed than Ron expected. Ron wrote, Judge denied his little stunt. We called the bluff. Get this amenity finished and online and he won't dare touch it. No one wants to be the guy who bulldozes a finished house. Another board member chimed in. Once residents see it finished, he'll be the bad guy if he keeps pushing. Property values will turn the community against him. They were betting on social pressure and sunk costs. They built fast enough and marketed hard enough. They thought I'd fold, rather than be the villain who tore down a shiny new building. They didn't understand something simple. I didn't live in their community. I didn't answer to their property values. I answered to a deed with my name on it and a promise my father made me keep. While they rushed to finish, David and I tightened our side. Karen, the surveyor, updated her report to include the partially completed structure, adding new photos, measurements from the foundation corners, and GPS coordinates overlaying the house footprint on top of my legal description. Her written conclusion, the amenity structure is located entirely within the metes and bounds. Description of the Mitchell parcel, the corrected plat filed. April 12th does. It's not aligned with historic survey markers or the original approved PLAT. No instrument of conveyance from the PLAT assists in the record to justify any boundary shift. David's title counsel contact an old colleague who'd spent 20 years cleaning messes like this for insurance companies, put his opinion in writing too. The plat correction is void without an underlying conveyance from the true owner. The easement executed by Mitchell Ridge Holdings, LLC is a nullity. That entity never held title and could grant no rights. The HOA has no recorded easement, license, or fee simple interest that would authorize construction of any structure on the disputed strip. As record owner, the Mitchell parcel owner retains full rights to exclude and to remove unauthorized improvements. David printed the opinion on letterhead and handed it to me in his office. This is what a judge will see in a quiet title action, he said. But you don't have to wait for that to finish. This is enough to justify what we talked about. Removal, I said. Removal, he confirmed. The final notice was the last courtesy. We drafted it together, careful and precise. No emotion, no threats, just facts and a deadline. 2. Lakeview Ridge HOA and Board of Directors. RI. Final notice: unauthorized structure on Mitchell Parcell. Have constructed a structure, the amenity house, wholly on my fee simple property without permission. The boundary correction and purported easement are void. No conveyance from me exists, and the entity named as grantor never held title. You have been provided with licensed surveyor's report confirming the true boundary and encroachment. A title opinion confirming you hold no rights to build on my land. You are hereby given 10 calendar days from receipt of this notice to cease all work on the structure and remove the structure and all related improvements from my property and restore the disturbed land to its prior condition. If you fail to comply within this period, the structure will be treated as a trespasser improvement, and I will arrange for its removal at your expense. Materials will be secured and stored. I will pursue recovery of costs and any additional remedies available under law. We sent it certified mail to the HOA's address, to Ron personally, and to their attorney. We also emailed PDF copies. They signed for the certified envelopes 2 days later, on day 3. Ron sent a reply. A terse email CC'd to half the town. We are not responding further to this neighbor's internet lawyer letters. My position is clear. We have recorded documents and a valid permit. Any attempt by him to interfere with or damage HOA property will be met with immediate legal action. He is a keyboard cowboy trying to scare us. We're not scared. He sent that to his board, his attorney, and done intentionally to one homeowner, who'd quietly been forwarding everything to David. We printed it and added it to the file. On day 10, nothing had been removed. The house now had shingles, windows, and doors. The interior framing was done. They'd even started running rough electrical. The deadline expired at midnight on day 11. At 7 a.m., a white truck with a bonded demolition contractor's logo rolled up my gravel access road and parked just inside my property line. Behind it was a lowboy trailer carrying a compact excavator and a skid steer. I was waiting at the gate with coffee, hard hat, and a folder of documents. The contractor, a stocky man named Alvarez, with 20 years in the business, got out and shook my hand. You the owner? Yes. You got paperwork? Handed him copies of the deed, survey, title opinion, demand letters, and the final notice. He flipped through them, nodded once, and handed them back. My guys don't touch anything until the cameras are rolling, he said. You said you've got recording set up? 3 motion-activated cameras were mounted on posts along the fence, angled to capture everything on both my side and the construction site. I walked him through the feeds on a tablet-wide shot, mid-shot, and a close-up on the structure itself. All right, Alvarez said. He turned to his crew. We're treating this as trespasser material. No smashing if we can help it. Deconstruct what you can, demo what you have to. We're stacking usable lumber on his side, scrap in the dumpsters. Everything we do is by the book. He looked back at me. Once we start, we don't stop unless law enforcement tells us to. You good with that? Yes. He checked his watch. Crew meeting in 5. We roll at 7:30. I stood there in the cool morning air, watching his crew unload tools and lay out tarps, while the cameras blinked their little red lights, recording everything. The HOA had been given every chance, more chances than they deserved. They'd chosen arrogance, bluff, and email bravado. Now the only thing left on the table was a simple question. What happens when you build a house on land that isn't yours and refuse to move it? In 30 minutes, they were about to find out. The excavator's engine rumbled to life at 7:32 a.m. The sound echoing across the hillside in the still morning air. Alvarez stood beside it, radio in hand, coordinating with his crew while I watched. From the fence line with the tablet showing all 3 camera feeds. Utilities first, Alvarez said into the radio. Miller, check the electrical junction, Carson, water line. Make sure nothing's lived before we touch the structure. 2 crew members, in hard hats and reflective vests, walked the perimeter of the house, checking for active connections. One called back. Electrical's roughed in but not connected to the grid. Water line stub is capped at the property boundary. No gas. We're clear, good, Alvarez said. He turned to me. You want to say anything for the record before we start? Walked closer, standing where the camera had a clear view of both me and the structure, and spoke clearly. Today is October 28th, 2024. I'm standing on property I own in fee simple. Recorded continuously since 1952, the structure behind me was built without my permission, entirely within my boundary, based on fraudulent documents. The HOA was given written notice and 10 days to remove it. They refused. I'm now exercising my rights as the property owner to remove this trespass. I stepped back. Alvarez nodded to his crew. Let's go. The work started methodically. To crew. Members climbed onto the roof with pry bars and began removing shingles, stacking them in neat bundles on tarps below. Others worked on the windows, carefully removing the frames and glass, setting them aside intact. The excavator moved to the corner of the structure, its bucket positioned against the exterior wall. Alvarez radioed the operator, slow and controlled. We're not smashing this. We're taking it apart. The bucket pressed against the plywood sheathing, applying steady pressure until the nails gave way and a section of wall peeled back. The crew moved in immediately, disconnecting the wall from the framing, lowering it to the ground with ropes, and stacking the salvageable plywood on wooden skids. It was surprisingly quiet work. No crashing, no chaos. Just the steady rhythm of deconstruction pry, disconnect, lower, stack, by 9 a.m. The roof was off, and the second floor framing was exposed. By 10 o'clock, the exterior walls were down, and the crew was working on the interior studs, separating usable lumber from damaged pieces. I stood at the fence, watching the cameras, making sure everything was documented. The tablet showed all three angles: wide shot of the full site, mid shot of the crew working, and close-up of the structure coming apart piece by piece. Then, at 10:23 a.m., a black Audi came roaring up the access road and screeched to a stop near. The fence Ron Callahan got out, his face flushed red, and started shouting before he'd even crossed the property line. "What the hell do you think you're doing?" he yelled, his voice cracking with fury. That's property. You're destroying community assets." I stayed where I was, calm, holding the tablet. It's my property. You built on it without permission. I gave you 10 days to remove it. You didn't. You can't just tear down a house. Ron shouted, walking toward the crew. Alvarez stepped between them, hands up. "Sir, you need to stay back. This is an active work site and you're not authorized to be here." Ron jabbed a finger at him. "I'm calling the police. You're all going to jail for this." "Go ahead," I said evenly. "Call them." Ron pulled out his phone, his hand shaking, and dialed. He paced near his car, yelling into the phone, while the crew kept working. Methodically disassembling the second floor, 2 sheriff's deputies arrived 20 minutes later. I recognized one of them, Deputy Garcia, who'd responded to a trespassing call on my property a few years back, when some kids had been joyriding on the access road. Ron rushed over to them, before they'd even gotten out of the patrol car. "He's tearing down our amenity house. It's destroying tens of thousands of dollars in property. You have to stop him." Garcia held up a hand. "Slow down. Whose property is this?" "Mine," I said, walking over with the folder of documents. "And the structure they're removing was built on my land without my permission." "He's lying," Ron said. "We have a recorded plat and an easement. This is HOA common area." Garcia looked at me. "You got proof this is your land?" I handed him the deed, the survey, and Karen's report. He read through them slowly, comparing the legal description to the GPS coordinates on the survey map. "And this survey's from last week?" he asked. "Yes. Licensed surveyor, Karen Delacroix. She's testified in dozens of boundary cases." Garcia looked at Ron. "You've got documentation saying you own this land?" Ron fumbled with his phone. "I have the corrected plat. It's recorded with the county." "A plat doesn't transfer ownership," Garcia said. "Do you have a deed showing this land was sold or transferred to your HOA?" "The easement," Ron started. "An easement's not ownership either," Garcia said. "It's a right to use. But even that requires the property owner's consent." He looked back at me. This your signature on the easement? No, the entity listed as grantor doesn't exist. I never signed anything. Garcia turned to his partner, a younger deputy named Larson. They had a brief, quiet conversation, then Garcia walked back to me. Look, this is a civil property dispute. If he thinks you're trespassing on HOA land, or you think he built on your land, that's for a judge to sort out.
We're not going to arrest
Anyone for working on property they say they own, especially when you've got a deed and a survey backing you up. He's destroying our property, Ron shouted. If it's on his land without his permission, it's a trespasser structure, Garcia said, calmly, and property owners have the right to remove trespasses. That's settled law. He looked at Ron. You want to stop this? You need a court order? We're not doing it. Ron's face went from red to purple. This is unbelievable. You're just going to let him. We're going to let the property owner work on his own land, Garcia said. If you've got a legal claim, file it. But don't call us back unless there's an actual crime happening. He nodded to me, got back in the patrol car, and drove off. Ron stood there, shaking with rage, staring at the crew as they continued dismantling the structure. Then, without another word, he got in his Audi and sped off. Kicking up gravel by 2 p.m., the house was down to its foundation slab. The crew had stacked usable lumber, thousands of board feet of studs, joists, and wooden skids. On my side of the property line, damaged or unusable material went into a roll-off dumpster Alvarez had brought. The windows, doors, and light fixtures were wrapped and stored separately. Even the shingles, barely used, were bundled neatly. Want us to break up the slab? Alvarez asked.
Oh.
Leave it for now. I'll deal with that later.
Oh.
He nodded. We'll grade the site, make sure it's stable, and clean up debris. Should be done by 5. I watched the crew finish, thinking about Ron's face when the deputies had refused to stop us. He'd been so sure, so confident that the law would back him up, that his recorded documents and his HOA's authority would trump simple property ownership. He'd been wrong. By 5:15 p.m., the site was clear. The house was gone. The land looked almost exactly as it had 6 months ago, before they'd started building. Alvarez handed me an invoice $14,200 for labor, equipment, and disposal land, a signed statement that everything had been done safely, lawfully, and in accordance with my written authorization. I paid him by check, thanked him, and watched his crew load up and drive off. Then I drafted a simple letter, attached photos from the cameras, and emailed it to Ron and the HOA board. Removal of trespassing structure, invoice for costs. The unauthorized structure has been removed from my property. Salvageable materials are stored on site and available for pickup by appointment. Removal costs totaled $14,200. An invoice is attached. Payment is due within 30 days. I hit send and went home. The lawsuit arrived by courier. 3 days later, Lakeview Ridge Homeowners Association v. My name complaint for damages, injunctive relief, and declaratory judgment. The claims were exactly what I expected: destruction of property alleging I demolished a lawfully constructed structure valued at $180,000. Trespass and interference with community assets, claiming the amenity house was common area property and I had no right to remove it. Intentional infliction of emotional distress, alleging residents were traumatized by witnessing the demolition. Injunction, demanding I be barred from interfering with any future construction or HOA activities. They were asking for $250,000 in damages, plus fees and costs. David read the complaint in his office, flipping through it with an expression somewhere between amused and annoyed. They're suing you for removing a trespassing structure from your own land, he said. This is going to get dismissed so fast it'll make their heads spin. What do we do? I asked. We answer. We file counterclaims. We do one more thing. He pulled out a blank pleading form. We file for declaratory judgment on title. We ask the court to issue an order declaring once and for all that you are the sole simple owner of the disputed parcel, that the corrected plat is void, and that the HOA has no rights to build or use your land. How long does that take? A few months, probably, but once we have it, This is over. No more games. No more fake plats. It's just a court order saying the land is yours. Period. Do it, I said. David smiled. With pleasure. The counterclaims we filed 2 weeks later were methodical and damning. Quiet title, seeking a declaration that I held sole. Unencumbered title to the parcel, trespass. Documenting the HOA's unauthorized construction and use of my land. Slander. Of title for filing the fraudulent plat and easement, which clouded my ownership. Fraud, alleging the HOA knowingly filed false. Instruments or recklessly disregarded their invalidity. Costs and fees seeking reimbursement for survey. Legal and removal costs, plus attorney's fees. We attached everything. Karen's survey, the title opinion, the demand letters, the sheriff's report from the day of demolition, photos of the completed teardown, and the invoice I'd sent to Ron, and quietly, as promised, David filed the petition for declaratory judgment, asking the court to issue a binding order on the one question that mattered: who owns the land? The HOA could bluster and threaten and claim emotional distress all they wanted, but if the court said the land was mine, and it would, then everything else collapsed. The house had been a trespass. The removal had been lawful. And every dollar they'd spent building it had been wasted on land they never had the right to touch. Ron had called me a keyboard. Cowboy. Now he was about to find out what happens when the cowboy shows up with a deed, a survey, and a demolition. Crew Dotton doesn't blink. Discovery began in January and ran for 3 months. It was the part of litigation most people find tedious, endless document requests, depositions, interrogatories, but it was also where the truth came out. Line by line, email by email. David requested everything. All communications between the PTE, HOA board, and the developer regarding the boundary. All documents related to the corrected plat and easement, meeting minutes. Financial records showing payments to surveyors and attorneys, and any correspondence mentioning my property or the amenity house. The HOA's attorney, Benson, fought every request, claiming privilege, burden, and irrelevance. But Judge Marone, who'd been assigned the case, had little patience for obstruction. "This is a title dispute," she said during a case management conference. "The plaintiff claims they had the right to build. The defendant says they didn't. Discovery on that issue is directly relevant. Produce the documents." Benson produced them. Slowly, grudgingly, in tranches that arrived one box at a time, and in those boxes, we found everything. The first smoking gun was an email chain from 2022 between the developer's project manager, a man named Kyle Forrester, and the Den HOA. President, a woman named Linda Marsh, from KFOR, Rester, at summitdev.com to lmarsh.lakeviewhoa@gmail.com. Subject: Phase 2. Boundary issue date: March 14th, 2022. Linda, our surveyor flagged a problem. The amenity parcel we planned for Phase 2 guest house concept. It's about 30 feet onto the neighbor's property. The Mitchell parcel, original plat from 2018, is accurate. We just didn't notice the overlap. When we were designing the amenity, options, (1), redesign and move the building footprint east, loses the view. Kills the concept. (2), approach the neighbor and try to buy or lease the strip, risky. Might say no or demand too much. (3), file a corrected plat claiming a surveyor error and adjust the boundary on paper. If the neighbor doesn't notice or object, we're good to go. If he does, we negotiate after the fact when the building's already up and he's less likely to push for removal. What's your preference? Kyle. Linda's response, sent 2 days later. Kyle, option 3, the neighbor Mitchell hasn't been around much lately. I think his dad just passed and he's dealing with that. If we file the correction quietly and move forward, I doubt he'll even check the records. And if he does complain later, we'll offer him something to make it go away. Let's not delay Phase 2 over a line on paper. Just get it done. Linda. David printed the email and handed it to me across his desk. That's conspiracy to commit fraud. In writing, there was more. Another email from Kyle to Linda, dated April 2022. Surveyor drafted the corrected plat. We need a conveyance or easement from Mitchell to make it legit. But he's not responding to calls if he even knows we tried honestly. Not sure anyone reached out. My attorney says we can't file without his signature unless we create a shell entity and execute documents as if we had authority. Not exactly clean, but it papers the file. Linda's reply, do what you need to do. I'm not telling the board we're delaying again. If it's a problem, we deal with it later. Kyle forwarded that exchange to an attorney named Richard Holt, asking, can you draft the easement and create an LLC as grantor? Holt's response was cautious but complicit. I can draft the documents, but I want it on record that this is irregular. If the actual property owner challenges, these instruments won't hold up. You're essentially creating a paper trail to support a boundary claim you don't have clear title to. That said, if no one objects, it works. Your call, Kyle replied. Draft it. 2 weeks later, Mitchell Ridge Holdings LLC appeared in the recorded easement, an entity that had never been registered, never held title, and existed only on that one document. We deposed Kyle Forrester in March. He was in his 40s, sunburned and uncomfortable in a suit, and he crumbled within an hour. David walked him through the emails methodically, one by one, until Kyle finally admitted we knew the building was on his land. We thought if we filed the corrected plat and got the permit approved, he wouldn't find out until it was too late to stop us. Or if he did, we'd just settle. Did you ever contact the property owner before filing the corrected plat? David asked. Did you ever attempt to negotiate a purchase or easement? No. Did you create Mitchell Ridge Holdings LLC? Kyle hesitated. My attorney did. For what purpose? To execute the easement so we could file it with the county and move forward with the project, even though that entity didn't own the property and had no authority to grant an easement? Kyle's attorney interjected, but the damage was done. Kyle nodded. Yes. Linda Marsh's deposition was worse. She'd resigned from the board in 2023 after Ron took over and had moved out of state. But we tracked her down and deposed her remotely. She confirmed everything. The decision to file the corrected plat without the property owner's knowledge, the creation of the fake LLC, the deliberate choice to deal with it later, rather than approach me honestly. When David asked her if she understood that filing a false easement was illegal, she got defensive. We were trying to build something for the community, she said. We weren't trying to hurt anyone. It was just easier this way. Easier than asking permission, David asked. Yes, Ron Callahan's deposition was defiant, claimed he hadn't known about the corrected plat's origins when he became president, that he'd relied on prior board assurances that everything was legal, and that he'd acted in good faith. But under questioning, he admitted he'd never verified the documents, never asked to see my signature, and never questioned why the grantor on the easement was an LLC when the property had always been held by individuals. I trusted the previous board, he said. But once my client objected and provided a survey showing the house was on his land, you kept building anyway, David said. Ron's jaw tightened. We had a permit. We had recorded documents. We had a right to finish. Did you ever look at his deed? No. Did you ever check if Mitchell Ridge Holdings actually existed? No. Did you ever ask an attorney to verify whether the easement was valid? Ron hesitated. Our attorney said we were fine. It's based on what? Based on the recorded documents. David let that sit. So you relied on documents you never verified, filed by people who admitted they created a fake entity. And when the real property owner objected with proof, you called him a liar and kept building. Ron didn't answer. The expert testimony came. In April, Karen Delacroix, the surveyor, testified that the corrected plat had no basis in physical reality. The original boundary markers were still in place. It's unchanged since the 60s, and the correction simply moved a line on paper without any corresponding change on the ground. A plat correction is supposed to fix an error, she said. This wasn't fixing an error. It was creating a new boundary to justify a building they wanted to construct. David's title expert, a man named Raymond Oster, who'd worked in title insurance for 30 years, testified that the easement was void from the beginning. An easement can only be granted by someone who owns the property, he explained. Mitchell Ridge Holdings never owned this land. The entity doesn't exist in any state corporate registry. The signature on the easement has no legal effect. The equivalent of me signing away your house meaningless? Could the county's acceptance of the recording change that? Benson asked on cross. No. Recording a void document doesn't make it valid. It just makes it a recorded void document. Judge Marin issued her ruling in late May after a one-day bench trial where both sides presented their evidence. O sat in the courtroom with David, watching her take notes, ask pointed questions, and occasionally glance at Ron with an expression that suggested she'd already made up her mind. Her written order came down a week later. It was 12 pages, single-spaced, and methodical. Findings of fact. The Mitchell parcel has been owned continuously by the Mitchell family since 1952, recorded in fee simple with no encumbrances related to Lakeview Ridge, HOA, Mitchell Ridge Holdings. LLC does not exist and has never held title to any portion of the disputed property. The easement executed in the name of that entity is void ab initio and conveys no rights. The corrected plat, filed in April 2024, purports to adjust a boundary. Without any underlying conveyance from the true property owner, it is invalid. The amenity house was constructed entirely on the Mitchell parcel, 22 to 38 feet. Inside the recorded boundary, defendant provided written notice and a 10-day opportunity to remove the structure. Plaintiff ignored the notice. Conclusions of law. Declaratory judgment. The disputed 0.4-acre parcel is, and has always been, part of the Mitchell property held in fee simple by defendant. Plaintiff has no ownership interest, easement, or right to use said parcel. Invalid recording. The corrected plat and easement recorded by plaintiff constitute a cloud on defendant's title and are hereby declared null and void. The county recorder is directed to note these instruments as voided by court order in the official record. Trespass. Plaintiff's construction of the amenity house was an unauthorized trespass. Defendant, as the fee simple owner, had the legal right to remove the trespassing structure. No damage is owed. Plaintiff's claims for destruction of property, emotional distress, and injunctive relief are dismissed with prejudice. Defendant owed no duty to preserve a structure unlawfully placed on his land. Abuse of process. The court notes that plaintiff, through its agents and prior board members, abused the county's recording processes to expand its footprint without lawful authority. Such conduct undermines the integrity of property records and imposes undue burden on true owners to defend clear title, fees and costs. Defendant is awarded attorney's fees and costs in the amount of $52,400, plus documented removal costs of $14,200 for a total judgment of $66,600. Judge Marin's final paragraph was pointed. Property rights are foundational to our legal system. When an entity files false instruments to claim land it does not own, constructs improvements without the owner's consent, and then sues the owner for protecting his property, the law must respond clearly. Such conduct will not be tolerated. Defendant acted within his rights. Plaintiff did not. David set the order down and smiled. That's as clear as it gets. He won completely. The HOA had 30 days to appeal. Ron called an emergency board meeting 2 days after the ruling, and someone recorded it and sent me the audio. Ron's voice was strained, angry, desperate. We're appealing. We have to. We can't just accept this. A board member I didn't recognize the voice pushed back. Ron. The judge said we abused the system. She said we filed false documents. If we appeal and lose, we're just going to owe more in fees. We're not losing, Ron snapped. We had a permit. We had recorded documents. A higher court will see that. We had fake documents, another voice said quietly. The LLC didn't exist. The judge spelled it out. We're done. I'm not done, Ron said. But he was. The appeal was never filed. 30 days came and went, and the judgment became final. The HOA paid the $66,600 3 weeks later, in a check signed by the treasurer with no cover letter, no acknowledgement. Nothing. Ron resigned the following month, and the corrected plat easement, those carefully crafted lies that had started everything were formally voided from the county record, stamped with a notice that read, "Declared null and void by order of the court. Case No. CV 202-48873, Mitchell v. Lakeview Ridge. HOA. The land was mine. It had always been mine, and now there was a court order, signed by a judge, that said so in language no one could misunderstand. The land settled back into its old rhythm over the summer. The foundation slab where the amenity house had stood was broken up and hauled away by a contractor I hired in June. By July, I'd brought in topsoil, reseeded the disturbed area, and let it grow wild. Within a few months, you couldn't tell anything had ever been there. The boundary was remarked with permanent monuments, concretes at iron pins placed by Karen's crew at every corner and every 100 feet along the southern line. Clear, professional, undeniable. I had the survey recorded with the county attached to the court's declaratory judgment. So anyone pulling records in the future would see exactly where my property began and ended. The salvaged materials from the teardown sat on wooden skids near the barn for a few weeks, while I figured out what to do with them. The lumber was good clean studs, joists, plywood, all barely used. I donated most of it to a nonprofit that built low-income housing too. County's over. They sent a truck, loaded it up, gave me a receipt for the tax write-off. The windows and doors I sold to a salvage yard. The shingles went to a contractor who was happy to get them at cost. Nothing was wasted. The HOA had paid for it with their lawsuit settlement, and now it was helping people who actually needed it. The gravel access road stayed mine. I kept it maintained, same as I always had, and I used it every weekend to check the fence line and move equipment. No HOA signs, no gates. Just a private road on private land, doing what it had done for 70 years. The new reality was simple, and I made it clear in a letter I sent to every household in Lakeview Ridge a month after the judgment became final. 2. Property boundary and access. The court has confirmed that the 87-acre parcel bordering your community is privately owned and has been since 1952. The corrected plat and easement filed by your prior board were void and have been removed from the record going forward. The boundary is clearly marked with survey monuments. Please respect it if you'd like to request permission for limited access, for example, a walking trail to the creek. Contact me in writing. I'll consider reasonable requests. Any attempt to file documents claiming rights to my land or to encroach without permission will be met with immediate legal action. I have no interest in conflict. I just want my property left alone, as it should. Have been from the start. It wasn't hostile. It wasn't warm. It was just honest. Over the next few months, a handful of residents reached out. Most were apologetic, saying they'd believed Ron's version of events and hadn't realized the board had filed fraudulent documents. A few asked if they could use a narrow foot trail that ran along the creek, something the kids had been using for years to get to a swimming spot downstream. I met with them individually, looked at the trail, and said yes. We signed simple one-page access agreements. Permission to use the trail for recreational access, revocable at any time, no structures or improvements, liability waived. Plain English, no legal jargon, just common sense on paper. One woman, retired teacher named Susan, thanked me with tears in her eyes. I was terrified you'd fence everything off and we'd lose the creek access. I didn't know Ron had lied to us. I'm so sorry you didn't do anything wrong, I said. Your board did. You just got caught in the middle. She nodded, took the signed agreement, and shook my hand. A small group of residents, led by a man named Greg and a woman named Patricia, started what they called the Lakeview Neighbors Group. It wasn't an HOA. It had no covenants, no enforcement power, no dues. Just a voluntary email list and occasional potlucks to talk about shared concerns, snow removal coordination, a neighborhood watch, maintenance of the community entrance sign. Patricia invited me to the first meeting held in someone's backyard on a warm August evening. I almost declined, but something made me go. About 20 people showed up. They were friendly, cautious, clearly unsure how I'd react after everything that had happened. Patricia stood and introduced me simply. "This is our neighbor. He owns the land to the north, and he's been more patient with us than we probably deserved." I kept it short. "I'm not interested in being part of a homeowners association, but I'm happy to be a good neighbor. If you need something access, clarification on the boundary, whatever, just ask. Respectfully, in writing. I'll do my best to work with." "You," Greg raised his hand. "What if someone in the community does something stupid again? Builds on your land or files fake paperwork?" "Then I'll handle it the same way I did this time," I said. "With a survey, a lawyer, and the deed my great-grandfather recorded in 1952. But I don't think that'll happen again. You've all seen how it ends." A few people laughed nervously. Patricia smiled. "Fair enough. I think about that day a lot. The morning the excavator fired up and the crew started dismantling the house. I didn't want it to come to that. Never wanted to tear down a building, never wanted to spend months in court. Never wanted to be the guy who stood at a fence line with a deed and a survey while someone screamed that I was destroying their community. But Ron and his board had left me no choice. They could have asked permission before they built. They could have negotiated honestly. They could have admitted their mistake when I showed them the survey and the title report, and we could have worked something out, maybe an easement, maybe a purchase, maybe just moving the building 30 feet east onto land they actually owned. Instead, they lied. They filed fraudulent documents. They built anyway. And when I objected, they called me names, threatened me, and doubled down on their lies. The only thing that stopped them was the same thing that stopped people like them for centuries. Property law. It's slow. It's boring. It's built on old paper and dusty records and boundary markers set in concrete. But it works. Because when you strip away all the bluster and legal buzzwords and appeals to community values, property law asks one simple question: who actually owns the land? And whoever holds the deed wins. Ron had fake plats and recorded easements and a building permit. He had a legal team and deep pockets and the confidence that comes from thinking. You can paper over reality, but I had a deed. A continuous chain of title going back 72 years. Survey monuments placed by my grandfather, and the patience to let the law do what it does best. Protect the person who actually owns the property. I stand on the ridge sometimes, looking south toward Lakeview Ridge, and I think about how close they came to getting away with it. If I'd been gone another month, the house would have been finished. If I hadn't checked the county records, I might not have known about the fake plat. Until years later? If I'd been intimidated by Ron's threats or discouraged by the judge denying the injunction, I might have just let it stand. But I didn't, because my father left me that land with a single instruction. Don't let anyone take this from you, and I didn't. The house is gone. The fake documents are voided. The boundary is marked. And every person in Lakeview Ridge now knows exactly where my land begins and theirs ends. Not because I'm powerful. Not because I had more money or better lawyers, but because I had the deed. And in the end, it's the only thing that matters. The lesson isn't complicated. When people abuse power, they don't actually have when they file fake documents. Claim land they don't own. It's build on property that belongs to someone else. They're betting that the real owner won't notice, won't care, or won't fight. Sometimes they're right, but sometimes the owner shows up with a deed, a survey, and the kind of calm persistence that comes from knowing you're standing on solid ground. Property law is slow. It's tedious. It's built on arcane rules and paper trails that most people never look at, but when it finally speaks, it speaks for whoever really holds the deed. And if you build on land that isn't yours, don't be surprised when the real owner decides what stays and what comes down. Ron learned that lesson the hard way, and now, every time someone in Lakeview Ridge looks north toward my property, they're reminded of it. The land is still here. The deed is still valid. The boundary is still marked, and no amount of fake paperwork will ever change that, because in the end, the truth isn't what you file with the county, it's what's written on the deed, and my name's been on that. Deed since 20-1, my father's before. That my grandfather's before that, and my great-grandfather since 1952. 72. Years of unbroken ownership and not 1 inch of it belongs to anyone else.